Hello friends, welcome to EduSathi, your partner in education. In this video, we will be discussing the law of contract, which is very important as regards to all your law entrance exams. So let's start the concept of law of contract. What does a contract mean? Contract has a very basic definition, which is an agreement enforceable by law. So there are two important aspects to it. One is agreement and second is legal enforceability. The law of contract is dealt in the Law of Indian Contract Act 1872 in India. This is one of the oldest law which we have been following since the time of Britishers. The common perception in the minds of a layman is a contract can only be in writing. However, as per the law of contract in India, it may be in writing or oral. All the contracts which can be proved in the court of law, which have been entered by the parties, which are oral, can also be termed as contract. So it does not have to be necessarily in writing. So there is no specific mandate by law that it has to be in writing only. It can be in writing or oral. So let's understand the two important ingredients which come out from this basic concept, that is agreement and legal enforceability. First of all, what does an agreement mean? We enter into agreement into everyday life. There could be various types of agreement, like social agreement. One could be a social agreement. For example, I invite you for dinner tonight and you accept my offer. This is a social agreement. It could be a religious agreement wherein I offer that I will donate some amount of money into a temple, and the person who is managing the temple agrees to it, that yes, you can donate. So this also amounts to a agreement, but it's a religious agreement. For an agreement, there are two essentials. One is offer and acceptance, where two or more people agree on same thing in the same sense, they are said to be in agreement. However, agreement is a very broader term. To become a contract, it has to be a legally enforceable agreement. So the legal enforceability factor comes into play. A social or religious agreement would not be enforceable in the court of law. So these are not contracts, these are merely agreements. So to become a contract, agreement has to be a legally enforceable agreement. When one person does not do or refuses to do what was agreed, and other person can go to the court and force him to do it. So this factor amounts to the legal enforceability. Something which has been, if it has been an agreement in a contract, so the person would be able to take it to the court of law. In that case, the agreement would be termed as a contract. So these are the two important components of a contract. Let's discuss what are the fundamentals of contract. What we have discussed is there has to be an agreement and legal obligation. So this Venn diagram explains the whole concept of contract. This whole part is agreement, and this circle shows legal obligation. So when these two collide, this part amounts to contract. When these both things come together, it amounts to contract. One single thing would not amount to a contract. An agreement which is social or religious or moral or any other kind of agreement, it would not amount to contract until and unless there is a legal obligation attached to that agreement. So this Venn diagram shows that all agreements are contract, but all contracts cannot be an agreement. A contract is a sub part of the concept of agreement. Agreement is a broader term, and contract has a very specific approach. So the term which the line which is used here is all agreements are contracts, but all contracts are not agreement. This explains the scope of both these concepts. Thus, contract is equal to agreement plus enforceability before the law. So these important aspects of contract must be there to become a contract. These are few concepts which you need to understand before understanding the other intricacies and ingredients of a contract. So let's discuss. First is, a reasonable person should think that the parties intended to enter into a legally binding relationship. In a contract, there must be an intention in the minds of both the parties to enter into the legally binding relationship. If one person is thinking that it should be a contract, another person is just going by the concept of agreement, that person is not willing to go into a legally binding relationship. So it would not be a contract. So there has to be an intention in minds of both the parties. So the parameter what is used to determine whether the intention was there or not is, a reasonable person should think that there was an intention. So it does not amount upon the thinking of the parties, but a reasonable person, a parameter of a reasonable person's mind would be used to determine whether the intention was there or not. What is a legally binding relationship? A relationship from which a legally binding obligations arise is termed as legally binding relationship. Another term which need to be understood is intended. There must be a mental state to create the legally binding relationship. What does an intention mean? That both the parties must have the mental state to create the legally binding relationship. So it means they intended to enter into such contract. Another Latin term which comes into exams most of the times is consensus ad idem. That means meeting of the minds. It's a Latin term for meeting of the minds. When the two parties to a contract both have the same understanding of the terms of the agreement. For an agreement to become a contract, there must be a meeting of the minds. Both parties must be thinking and thinking in a same way with regard to the similar thing. Let's take an example that will explain you whether there is a consensus ad idem in this example or not. If Bill buyer said, I will buy all your stock, and he meant shares in the corporation. There is a one person, Bill buyer, and Sam seller said, I will sell all my stock to you, and he meant his cattle. So there is no meeting of mind. By stock, in this case, Bill meant shares in the corporation. So however, the Sam seller thought that he was talking about cattle. So he offered to sell his stock, which he meant cattle. So can this be a basis of a formation of a contract on the grounds of consensus? Yes, they agreed to buy and sell the stock, but the meaning of stock in their minds was completely different. So there was no meeting of the minds. So without consensus ad idem, there cannot be an agreement or contract for that matter. Let's take another example. For example, I offer that I want to sell you my car for 1 lakh. Similarly, you accept that yes, I will buy your car for 1 lakh. However, I have two cars. You were thinking that I was selling you my Honda City for 1 lakh. However, I thought that I will be selling you my Santro. So in this case, both the parties have different understanding about the concept of car. So this would not amount to a contract. Even if we put it in writing, it would not amount to a contract because there was no meeting of the minds and consensus ad idem. Even though all the conditions of the contract has been fulfilled, that we intended to enter into a legally binding relationship, and we had the mental state to create this relationship, but there was no consensus ad idem. That is also an essential aspect of the contract. So this is not a contract. What are the types of the contract? We classify contract on the basis of the validity and formation. On the basis of the validity, there are various types of contracts. First is valid, void, voidable, illegal. So these are the 4 types of contracts which are formulated on the basis of the validity. Before understanding all these terms, I must tell you that these are the terms which you valid, void, voidable, and also void ab initio, or you can say void ab initio. These are the terms which form the part of your legal vocabulary as well as vocabulary under the English section. Most of the exams like IELTS by NLUD or CLAT sometimes give these kind of terms in the English vocabulary section also. So you must understand what does these terms mean. So let's understand what is valid contract. Valid contract is which has all the essentials of a contract satisfied before entering into it. So it's a valid contract and enforceable in the eyes of law. Second is void contract. Void means illegal. Not illegal, it means not a valid contract. Anything other than valid contract is void. Void could be void ab initio. Void ab initio means from the very beginning. Ab initio is from the very beginning. Void is not right from the very beginning. So void agreement is due to certain reasons, which we will discussing in the other slides. Due to certain reasons, an agreement could be because the agreement is not valid from the very beginning. It does not result into contract. So it's a agreement which is not right from the very beginning due to certain reasons, for example mistake or misrepresentation, which we will be discussing in detail in next slides. Voidable is you can declare the contract, it becomes a contract, but it is voidable at the option of the either of the parties, because they can declare it voidable or not right or breach the contract on the basis of certain grounds. So it's a voidable on the discretion of one of the parties. It's not void from the very beginning, as we have discussed in case of ab initio, that is not right from the very beginning. Illegal agreement, similarly there is no contract if it's illegal. Like we discussed in case of void, it does not result into contract, so it remains agreement all throughout. Illegal agreement means which is not allowed by any law of land. For example, gambling is not allowed in India. Any agreement entered into during gambling would not be a contract, and it would be a illegal agreement. So these are the terms or types of contract which you need to understand before going into the details of contract law. Next is formation. How it is formulated, what were the bases on which it was formulated. First is express contract, where both the parties expressly, whether in writing or in an oral way, create a contract and expressly give the terms and conditions of the contract. That would amount to be an express contract. Second is implied contract. What does an implied contract mean? It means when through the actions of the parties it was implied that they intended to enter into a contract. They did not expressly provide that yes, we are entering into a contract. So there was not an express condition given, there were no express terms and consent. However, their act implied that they intended to enter into a contract. Next is quasi contract. Quasi contract is when a person, for example A, receives something without any consideration from B. So in this case it would be treated as contract by court of law as a quasi contract, because he received something without doing anything, without any consideration. He did not pay anything to B, but he received something or some property. So this would be dealt as a contract by the court of law. So it's a kind of a implied contract wherein there is no express term given, no express consent given, but the actions of the parties or some receiving or giving occurs, which will result into a quasi contract. So these are the types of contract on the basis of validity and formation. So these are the classifications on which it is divided. What are the essentials of a valid contract? We will just discuss it in brief, and because these essentials would be discussed in the further slides in detail. So first essential is offer and acceptance. We already discussed that one person must offer and other person must accept the terms of the contract. Intention to create legal relationship, there has to be an intention. there has to be lawful consideration. By lawful consideration means what a law would allow. For example, if you say that I enter into a contract with a serial killer, wherein I say that you kill somebody, then I will pay you certain amount of money. So it's a unlawful contract, and it would not amount to a lawful consideration for the act. Killing somebody is illegal, and this also comes under the essential of lawful object, because the object of the contract is illegal, that is killing somebody, so it is a invalid contract. So there has to be lawful consideration and lawful object for a valid contract. Capacity of the parties, that is competency. Both the parties must be competent enough to enter into a contract. It could be that he must not be minor, that is he must be more than the age of 18 years or above. Second competency parameter is that that person must be sane. Sane is of sound mind. A lunatic or idiot person cannot enter into a contract. The contract being entered into would be invalid contract because that person was not competent. Third is not stopped by law. The person must not be stopped by law from entering into the contract. For example, an insolvent person who has declared his insolvency cannot enter into any kind of financial contracts. So person is stopped by law from entering into the contracts. If any of these three persons enter into contract, that would not amount to a valid contract. Free consent means there must not be any kind of coercion or force or undue influence used by the party to get the consent of either of the parties. So it should be a free consent to result into a valid contract. Agreement not declared void. Something which is declared void and illegal by law would not, if anybody enters into a contract on the basis of such agreements, that would not amount to a valid contract, like we gave an example of gambling or for a contract of killing somebody, that is also an agreement declared to be void. Certainty and possibility of performance. The contract must be on the basis of those acts which can be certainly performed, and there is a possibility of performance. For example, impossible agreements cannot be a valid contracts. For example, if I say we enter into an agreement, A and B enter into an agreement. A says that I will break the stars for you, or I will go to Mars for you, or I will go to Sun for you. That kind of a contract is impossible. There's a impossibility of performance, so that is not a valid contract. Legal formalities. All the legal formalities must be filled up for the contract to be valid. Let's discuss offer and acceptance. How a contract is made. There are three ingredients to a valid contract. One is offer, acceptance, and consideration. A makes an offer to B, so there is a offer. B accepts it, so it can be a contract, and there must be some kind of consideration for the same offer. We have a contract between A and B. So these are the three essentials: offer, acceptance, and consideration. Offer and acceptance are the primary essentials of a contract. One must offer and the other must accept it. What is an offer? A says to B, I want to sell you my watch for ₹100. It's an offer. Tricky area. This offer has two things: watch and ₹100, that is consideration. An offer does not necessarily means only to buy, but also to sell. If you offer that I want to sell, that is also an offer. If you say I want to buy, that is also an offer. Only buying is not, only an offer to buy is not an offer. Also to sell is also amounting to offer. Means for a consideration, ₹100 would give you my watch. So if you give a consideration of ₹100, I would give you my watch. So this is the whole concept of offer. What is an acceptance? B says to A, I accept your offer. So he says that I will give you ₹100 for your watch. So he must accept the offer as it is. I've give you an offer of selling my watch for ₹100, so this person must accept in the same way. So he must accept that I will give you ₹100 for your watch. So this is an acceptance to this offer, right? So this means offer and acceptance, which results in a contract. Offer and acceptance, types of offer. There could be two types of offer. One is specific offer, other is general offer. Specific offer means when an offer is made to a particular person and that person can only give the acceptance, it's a specific offer. For example, A makes an offer to B that he wants to sell his mobile for ₹2,000. Over here, the offer is made specifically to B, and only B can accept this offer. C cannot come into play all of a sudden and say that yes, I want to buy a watch for 2,000. So this offer was made to B. It's a specific offer, and no third party can accept this offer on behalf of B or in place of B. Next is general offer, where the offer is made to the public and not to a specific person. It's called a general offer. For example, in case of these tenders and all, these are given to general public. Let's take an example. America advertised in the newspaper that if anyone find Al-Jawahiri, Taliban chief, will get reward of $10 million. Over here, it's a general offer because it is given to general public at large. Anybody from all throughout this world or in America finds this person would get the reward of $10 million. So it's a general offer. Essential requirements for offer and acceptance. How offer and acceptance are understood and determined. In case of contracts, communication of offer and acceptance is essential. The offer and acceptance must be communicated to the persons concerned. Communication means that you must get to know about the offer and acceptance by whatever means. We will understand this with an example. A had a reward out for whoever found his son S. B finds S. There's no mention of the reward to B. B find S but no idea about the reward. While finding S, he had no idea about the reward which was announced by A, his father. Finds about the reward only after he returned S to A. He gets to know about the offer later on, after the act has been already completed. Can B claim the reward? No, because in this case there was no communication of the reward to offer to the person B, so he cannot claim later on because he had not found S on the basis of the offer. He did it on his own, so there was no contract or acceptance of the offer by B. So there is no offer and acceptance in this case, and B cannot claim the reward from A. Next example, Jack wanted to marry Jane and accordingly proposed. In her heart, she accepted Jack as her husband but was too shy to accept. Jack married Anna. Jane sues Jack for breach of contract. So in this case, was there even a contract? Because in this case, Jack has proposed, but Jane had not accepted it because she was too shy to accept it. There was no communication. She accepted him as his husband in her heart. In her heart, so there was no acceptance communicated to Jack. So if Jack married somebody else, Jane cannot hold him liable for the breach of contract, because the most important aspect of offer and acceptance was not there and the acceptance was not communicated, so there was no contract in this case. Offer and acceptance must be clear, not vague, and should be absolute and unconditional, also unambiguous. So it says offer and acceptance must be clearly there and the acceptance should be unconditional and unambiguous. Example, A owned 3 flats X, Y and Z. B calls him and says he is willing to pay 1 crore for his flat. So it is not clear that which flat he wanted to buy. Even if A accepts the offer, there has to be clarity between in the offer. So there was no clarity in offer, so it would not amount to a valid offer and thus valid contract would not be entered into. B calls A and says he is willing to pay ₹1 crore for his flat X. X says, well, let's meet up and let's talk about the details. So was there any acceptance? No, because A's statement was vague. He did not say that yes, I accept your offer, but he just merely said that we will meet up and talk about the details. Later on, after meeting up, if they discuss the details and he accepts the offer of B, so then it would amount to a valid acceptance to a offer, and it would result into a contract. But in this case, there was no acceptance in the words given, so it would not amount to a valid acceptance. Offer and acceptance, another two concepts there. The general rule which is followed in a relationship or which results into a contract is there's an offer and there's an acceptance by the other person to that offer. It results in a contract, thus a legally binding relationship. The exception to this rule is invitation to offer. When A invites B to make an offer, it's a pre-stage to the offer. There's no offer made, but one person invites the second to make an offer. For example, tenders are invitation to offer. The tenders are given, and the person giving out the tenders invites other people to make offers according to their convenience. For example, a tender to build up a building in a city. Government gives the tender, and government invites the people who could build the building as per their convenience, and the tenders are given. They give their tenders quoting the amounts and consideration they will receive for the act of building the building in the city. So tenders are invitations to offer and not the offers. Let's take an example. A had his shop a limited edition book, that is price of 1000. B came and put rupees 1000 on A's counter. So he had this limited edition book, but he had just given the invitation to offer. He might have publicized that I have this limited edition book, whoever wants to buy can come. So B came and put rupees 1000 on A's counter. A refused to sell. B said that since he had accepted the offer, there is a contract and A must hand over the book to him. So is it a valid contract? No, because there was just an invitation to offer, and just because B had put up an offer, A had full right to not to accept that offer. This does not amount to a contract, so A is not liable to hand over the book to B. Next is concept of postal rule. It applies when there is no instantaneous mode of communication. In case the communication of offer or acceptance is given by way of postal mode, in that case it would take certain time to reach the person. So what rules are applied in case of postal communication? Let's take an example to understand the concept of postal rule. Example: A writes a letter to B saying he wants to sell his house to him for rupees 1 crore. B write a letter back accepting A's offer. B's letter reaches A after 15 days. It took 15 days for B's letter, that is accepting letter, to reach A. Meanwhile, A sells the house off to C. B sues A for breach of contract. B was bound by his acceptance on the so let's understand the concept, how B would be bound. A had written a letter to B for selling his house, so there was an offer. So when the offer reaches B, offer is complete. B has accepted the offer, but the acceptance and the communication of acceptance would be complete once it reaches the person making the offer, that is A. Since it had reached A after 15 days, till the time it was not it had not reached A, it would not amount to contract, because the communication of acceptance in case of postal mode is complete once it reaches the person making the offer. So if the acceptance was not complete, there is no contract. So in this case, B was bound by his acceptance on the day he put the letter in the mode of communication. So in this case, B cannot back out, because from the point of view of B, acceptance is complete because he's already posted out the letter. So if the letter had reached A and later on B had breached the contract, A would make B liable for his acceptance, that is the breach of contract. But in this case, the A had already sold off his house, so in this case B was bound by his acceptance on the day he put the letter in mode of communication. A would be bound by B's acceptance only when gets the letter, that is on the 15th day. If before 15th day he executed the property or sold off the property, he would not be held liable for the breach of contract, because the contract was not complete due to the lack of communication of acceptance. So the tricky area is, till such time A is not bound by the contract, because there is no contract as it is. As far as A is concerned, there is no contract. The contract is complete only from the point of view of B and not A, so he cannot be held liable for the breach of contract. Let's take the problem. If a person accepts an offer made by a person, then the contract is formed. Facts: Prabodh is keen on selling his car to Ritikesh and tells him that he is keen on selling him his car for 1 lakh. Ritikesh tells him that he will certainly buy the car for the said amount, but requests Prabodh to paint the car white. So there is a condition attached to it, right? A few weeks pass by and Prabodh receives an offer from Mikey, who is willing to pay rupees 2 lakh for the same car. Prabodh sells the car to Mikey. When Ritikesh finds out, he is very upset and sues Prabodh, alleging that he had breached the contract and which he had entered into with him. So let's decide. So in this case, there was an offer, right, that he wants to sell, and there was an acceptance by Ritikesh, but there was a condition attached to it that he would want him to paint his car white. So let's take the options to decide whether it's a valid contract or not. A. Prabodh is liable for the breach of contract because the contract was acceptance in its material particulars. This can be an answer, because he can be held liable because it was accepted in the material particulars. Prabodh is not liable because the contract was not accepted. This can also be an answer, because acceptance should be clear, unambiguous and unconditional, like we had discussed in the previous slides, that it has to be unconditional, but in this case it was a conditional acceptance, so it is not a valid acceptance. Prabodh is liable because this was clear case of promissory estoppel. No, it's not an option. Prabodh is not liable because he was entitled to revoke his offer. No, it's not a answer. So the answer could be amongst these options: either he is liable or not liable. So the answer is this one, because it gives a valid reasoning behind it, because the acceptance was not complete, so it's not a valid contract. The acceptance was conditional, so there was no contract entered into, so Prabodh cannot be held liable for the breach of the contract. Let's take another example. A contract is completed when offer is accepted by the other party. Facts: Amitabh and Rekha are negotiating a contract under which Rekha will supply ball bearings to Amitabh's industrial unit. During the telephonic negotiation, Amitabh says, "I will buy your ball bearings at ₹2 a piece." Rekha's response is drowned out by the aeroplane flying overhead. Is the contract complete? Like we discussed, there has to be the communication of both offer and acceptance to the respective parties. In this case, the communication of the acceptance, that is Rekha's response, was not complete due to the aeroplane flying overhead, due to the excessive noise by aeroplane flying. So the communication of acceptance is not complete in this case. Let's take the options to decide upon the right answer. A. The contract is complete as long as Rekha said yes. No, the acceptance must reach the offerer. The contract is not complete since Rekha did not say yes. Yes, she did say yes, but it did not reach the offerer, so this is not an answer. C. The contract is not complete since Amitabh did not hear the yes. So this can be an answer. She said yes, but communication was not complete because he did not hear the acceptance. The contract is not complete since Amitabh did not make a proper offer. No, this is not a question, because he made a valid and proper offer by saying that I will buy your ball bearings at rupees 2 per piece. So this is a valid offer. So the only answer left out is that it's not a contract, because Amitabh did not hear the yes. That means the acceptance communication was not complete from the part of Rekha to Amitabh, so it's not a valid contract. Let's understand what are the ingredients of a contract. What does a contract require to be a legally valid? All agreements are contracts if they are made with free consent of the parties competent to contract, that is competency of the parties, for a lawful consideration, that is lawful consideration, and with a lawful object, that is lawful object, and are not hereby expressly declared void. It is given under the section 10 of Indian Contract Act 1872, that it must not be expressly declared void, like we discussed illegal contract or gambling contracts which are expressly declared void by the law. All 5 must be present for a legally valid contract. So these are the essentials of a contract to form a legally valid contract. Thank you. Please continue watching the next video of Contract Law 1, because we will be discussing the ingredients of a contract in the next PPT. Thank you.